everyone, and welcome to this podcast that will be dedicated to the ruling Digital Rights Ireland. I'm Laviro Buono. I'm the head of Section 3 at ERA. Section 3 deals with European criminal law. In our seminars, in our conferences, we cover topics such as trafficking of human beings, fight against cybercrime, money laundering, defense rights, victims' rights, so on and so forth. In 2022, ERA turns 30. And to mark its 30th anniversary, we thought of launching a very special podcast series, 30 years of ERA, 30 cases of the Court of Justice of the European Union. In this podcast, as I said, we will focus on the ruling Digital Rights Ireland, a ruling of April 2014, where the Court of Justice in Luxembourg invalidated, annulled the EU Data Retention Directive of 2006, which required private providers to retain for a considerable period electronic communication metadata for law enforcement purposes. The court considered that such data retention obligations went beyond what was strictly necessary and violated the Charter of Fundamental Rights of the European Union. In many member states having a national data retention regime, this has now been challenged before the respective constitutional courts. In this podcast, we will scrutinize the significance of this landmark judgment, and we will do so by asking few key questions to David Fennelly, Irish barrister and assistant professor, School of Law, Trinity College, Dublin. Enjoy the podcast.
Laviero, thank you so much for the invitation to join you for this podcast. It's a pleasure to participate in this particular program. Before answering your questions, I should say at the outset that Digital Rights Ireland is a case in which I was involved as counsel on behalf of Ireland, and indeed I've been involved in a number of the subsequent cases that followed Digital Rights Ireland. So I'll be limited and careful in what I say in that regard today, and I'm speaking today in a purely personal capacity, and I won't address any of the pending litigation. But let's talk about Digital Rights Ireland, and in particular your first question as to why this judgment is important. And Digital Rights Ireland really is a landmark in the development of EU law in the era of the Charter. The Charter, as you know, took effect, full legal effect in 2009 with the coming into force of the Lisbon Treaty. And in the judgment in Digital Rights Ireland, we really see the impact of this new legal effect of the Charter. In that judgment, the court examined the validity of the Data Retention Directive. This directive obliged member states to require telecommunication service providers to retain telecommunications metadata, that is the subscriber, traffic and location data, not importantly the content of electronic communications, so that this data would be available if required in appropriate cases for the purposes of fighting serious crime, including terrorism. And in the court's judgment of the 8th of April 2014, the court examined the validity of that directive by reference to the Charter of Fundamental Rights. The court recognized that data retention served an important public interest in the fight against serious crime, but it considered that the directive in the form it had been adopted constituted a very serious and far-reaching interference with fundamental rights. And for that reason, the court said that it had to assess the directive in a very strict manner, and the discretion of the EU legislature was limited. And looking at this directive, the court said, because of its generalized nature and because of the absence of appropriate safeguards built into the directive in respect of access to telecommunications data, the directive constituted a disproportionate interference with the rights to privacy and data protection guaranteed under Articles 7 and 8 of the Charter of Fundamental Rights. And on that basis, the Court of Justice declared the directive invalid. Now, while in a number of earlier cases, the court had struck down individual provisions of EU legislation by reference to the Charter, Digital Rights Ireland was the first case in which the Court of Justice struck down an entire directive, an entire piece of EU legislation on the basis of the Charter rights. And for that reason, it represents a landmark in the development of EU constitutional law. And in later years, we've seen some of the implications of that status of the Digital Rights Ireland judgment. So Laviero, in Digital Rights Ireland, what we see is a particularly robust interpretation of the Charter of Fundamental Rights. And the Digital Rights Ireland judgment has been cited regularly in the court's subsequent case law and indeed by national courts in the area of EU law, not only in the area of data, privacy and so on, but also far beyond that. What is significant about Digital Rights Ireland for the development of EU law and EU fundamental rights law, I would say, is that in that judgment, the court applies a very strict standard of review or scrutiny of EU measures which interfere with the rights to privacy and data protection. Now, that same strict scrutiny is not necessarily evident across the board when we see how the court approaches the Charter of Fundamental Rights. But it represents, I would say, the high point of the court's Charter of Fundamental Rights jurisprudence. And it's been an area which the court itself has laid particular emphasis in over the past decade. And so to give you one high-profile example of the effect of Digital Rights Ireland and its contribution to the development of EU law beyond data retention, if we look at the area of international data transfers, we see that contribution in a very vivid and dramatic way. Following the court's judgment in Digital Rights Ireland, in a number of references from the Irish courts, the Court of Justice has been called upon to examine the validity of EU-US data transfer arrangements in the Schrems I and Schrems II cases. And in the court's judgments in those cases, we see the court applying the same very strict standard of review in assessing the Commission decisions allowing such transfers, and many of the same substantive principles and safeguards that are recognized explicitly in the Digital Rights Ireland being employed in this context. And in those judgments, the court invalidated first the safe harbor judgment in Schrems I, and secondly, the privacy shield decision in Schrems II by reference to the same Charter of Fundamental Rights provisions that it had relied upon in Digital Rights Ireland. So that's just an example of that broader contribution and impact of the judgment on EU law more generally. It's been one of the striking features of the court's jurisprudence under the Charter of Fundamental Rights. Turning then more specifically to the development of EU criminal justice, that's a slightly more complicated story. Because the Data Retention Directive, even though it intervened in the field of criminal justice in a significant way, was in fact an internal market measure. It was adopted under what was then Article 95 of the Treaty on the European Communities. But the directive and its striking down have had serious implications for law enforcement. And this has indeed led to a series of further references from national courts in the wake of the Digital Rights Ireland judgment, seeking to tease out the effects of the court's case law for national legislation and by extension, national criminal proceedings. And this brings us to one of the really interesting elements of the judgment and its afterlife, if we can call it like that. How does EU law and EU constitutional law manage or address the consequences of an entire piece of legislation, an entire directive being struck down? And because Digital Rights Ireland is the first time we see this happen, it is also the first case in which we see the implications of that fully being teased out. And that indeed is an ongoing process. What's significant in this regard is directives by their very nature require national implementing or transposing measures in order to take effect in member state legal systems. So the process of working out the consequences of the invalidity of directive are much more complicated than, say, would be the case in respect of the striking down of a regulation which might be directly applicable. And one practical implication when this touches on the area of criminal justice is what happens to ongoing criminal investigations and prosecutions and proceedings. And in the context of data retention, this has raised the question of evidence which is obtained under national legislation adopted in order to comply with the directive. Can that evidence, which might be very significant in the investigation or prosecution of a particular serious crime, be relied upon in the proceedings, in the trial, criminal trial against the particular accused individual? And the Court of Justice has addressed that to a certain extent so far and has been asked to address it further in some later cases. And this is an issue of major importance and sensitivity. It shows how measures such as the Data Retention Directive can have a very significant and unforeseen impact in the field of criminal justice. And it shows how the field of criminal justice in EU law is developing not only through measures directly adopted under the relevant treaty provisions, but also indirectly or more obliquely in ways such as this, including through the very real impact of the Charter of Fundamental Rights. So, Laviero, I've already touched a little bit upon the impact of the judgment of Digital Rights Ireland. And in your third question, you've asked me, what's its major impact been? Has it been forgotten? Has it been praised, further developed, or overturned? And what can certainly be said is that the judgment in Digital Rights Ireland has not been forgotten. It has been widely recognized as a landmark, as an important affirmation of the rights to privacy and data protection, rights which have really come center stage in recent years. So first and foremost, the major impact of the judgment has, of course, in a very direct way, been in the field of data retention. And I'll discuss that a little bit further in a few minutes. But the impact of the judgment extends far beyond this. It is a critical reference point in the fields of privacy and data protection in Europe more generally. And in the era of the GDPR, with increased attention on data protection and privacy, this is more important than ever. So many of the substantive principles laid down in the Digital Rights Ireland judgment, particularly regarding safeguards that are appropriate for data processing, are of a much wider relevance beyond data retention itself. The considerations underpinning the court's judgment are also relevant for the development, for example, of major databases, which might be developed, including in the field of law enforcement. So this is a very significant impact of the judgment beyond its strict terms, beyond the assessment of the Data Retention Directive itself. And more broadly, the very strict approach to the assessment of limitations on the right to privacy and data protection affects how data protection law operates on a day-to-day level across the Union and beyond. And that arguably is the real impact of the judgment in Digital Rights Ireland. Some of the overarching principles that are rooted in the rights to privacy and data protection under the Charter of Fundamental Rights affect all we do with personal data that falls within the scope of EU law, whether it's under the GDPR, whether it's under the law enforcement directive regime or otherwise. So following the striking down of the Data Retention Directive in Digital Rights Ireland, there have been a long series of further references from national courts seeking to explore the implications of that judgment for national data retention and access legislation. With the Data Retention Directive gone, the focus turned to Article 15 of the e-Privacy Directive, the only other provision of EU law which addressed data retention. This allowed member states to restrict the rights and obligations under the e-Privacy Directive for important public interest objectives, such as safeguarding national security, fighting crime, and so on, but always subject to the proportionality and compatibility with fundamental rights. And in the case law that has followed Digital Rights Ireland, the court has been asked essentially whether national rules comply with this provision. And a series of issues have arisen in this regard. First of all, there have been issues about the scope of the e-privacy directive and the extent to which it extends into the fields of criminal law and national security, which under one of its earlier provisions are said to fall outside its scope. But the court, in its judgments in Telly 2 and Privacy International and Quadrature du Net, has very clearly said that the national rules in this area, where they require the telecommunications service providers to retain the relevant telecommunications metadata, do indeed fall within the scope of EU law. And they're not excluded from the scope of EU law by reason of the fact that they may be used for national security purposes and so on. So this is very important when it comes to the competence of the Union and raises broader constitutional questions about the division of competence between the Union and the member states. But for the present purposes, the court has answered those questions very clearly in that respect. That brings us to the substantive compliance of national legislation with EU law. And two major sets of issues arise in this regard. The first dealing with the model of data retention that is permissible or not under EU law, and the second dealing with the safeguards that must attach to any data retention or access regime. So let's take those in turn. First, what model of data retention, if any, is permissible as a matter of EU law? And this was the subject of the court's judgment of 21st of December 2016 in Telly 2 Watson, references from the Swedish and the UK courts. And in this judgment, in this case, the court said that while EU law precluded any generalized retention of telecommunications metadata, what it described as the general and indiscriminate retention of such data, EU law did not preclude the targeted retention of telecommunications metadata, whether that be by reference to geographical, temporal, or other factors. Now, there the court is laying down a very specific solution or proposed model for data retention that it says could be compatible with Article 15 of the e-privacy directive. The complication is that that model proposed by the court has been said by some not to be workable or effective in practice. So, for example, the French Conseil d'État last year in its ruling of the 21st of April 2021 said very clearly that a model of targeted retention would simply not be effective for fighting serious crime or safeguarding national security. The Irish Supreme Court reached a similar decision in a case which it subsequently referred to the Court of Justice and which is pending before the court. And in the court's later judgment of October 2020 in Quadrature du Net and others, the court maintained its position that only targeted retention would be permissible in the context of the fight against serious crime. However, it said that in the context of the safeguarding national security, general retention could be permissible, but subject to very strict conditions being satisfied. So we see some development and nuance in the case law, but nonetheless a significant problem that remains there, at least when it comes to the fight against serious crime. And that's the subject of ongoing litigation before the Court of Justice, and we await the further judgments of the Court of Justice on that issue. So that's the first issue relating to the model of data retention. The second issue then goes to the safeguards that must attach to any data retention and access regime. And one of the strong points of the Digital Rights Ireland judgment was, of course, in articulating these safeguards that must be in place. For example, a requirement of prior review of access by an independent administrative authority or a court before the law enforcement authorities could access retained data. And the court, in its subsequent jurisprudence from Telly 2 up to Quadrature du Net and more recently Procurateur, has affirmed and reaffirmed these principles and these safeguards, and indeed developed them and amplified them in certain respects in response to further questions from the national courts. So that's what we've seen in the developments in the case law since Digital Rights Ireland. So the developments in the court's case law are also relevant for the developments in EU law more generally. And what's striking in this field is that many years on from the judgment in Digital Rights Ireland, we have still not seen a full legislative response to the Court of Justice's jurisprudence. So for its part, the EU legislature has not proposed any revised legislation which would be fully compatible with the court's case law. Similarly, at the national legislation, while there have been many developments, many proposals for new legislation, many revised pieces of legislation adopted and so on, nonetheless, there remains this broader question as to whether any of the legislative models fully satisfy the requirements of the Court of Justice's case law. And that comes back to the points I mentioned earlier in terms of the model that's been prescribed by the court in its jurisprudence, particularly in its Tele 2 and Quadrature du Net jurisprudence. Because in light of assessments such as that by the French Conseil d'Etat, the question arises as to whether any legislation could be enacted that would provide for an effective data retention regime that would be fully compatible with that model of targeted retention that's been proposed by the court. So that's created a significant difficulty on the legislative side in the response to the court's judgment. And that's something that's the subject of ongoing litigation and debate indeed before parliaments as well as before national courts. And I think in the coming years, we'll see further developments in that regard. But it attests to the landmark status of the Digital Rights Ireland judgment and the fact that its implications remain very relevant today and indeed remain to be fully worked out even to this day. So finally, in one sentence, what is to be learned from this case? Well, in essence, it is that the Charter matters, and the Charter matters particularly in the protection of privacy and personal data in the digital age. So Laviero, thank you so much for the invitation to join you for this podcast. It's been a pleasure to participate, and I look forward to joining you soon for another event at the Academy.